Good afternoon. This is Howard Nations, and thank you for joining us this afternoon because we've got some important material to cover with you, kind of bring you up to date on what's going on with Camp Lejeune. The first thing is that we have, if you want to ask a question, look down at the bottom of your screen, just to the left of center, and it says chat, and you put your chat, write your questions in the chat box, and then we'll get to the questions uh, at the end, or maybe at the end of a session. Uh, the the next thing is that I'm going to go through uh, what's going on right now with the court, and then I'll tell you what's going on with the settlement masters that are supposed to be trying to pull this whole thing together into a settlement. Then I'll tell you about what to do if you have a death case, because that's very important and that's very relevant right now. And then we'll break for questions, and we'll try to stay and cover all your questions. So let's start with what's going on right now. In the court's latest report, there are 409,889 cases currently pending. Now, we started with 550,000, but the court went through and they eliminated 140,111 cases as duplicates. In other words, they were filed more than once. So that's the first topic I want to talk to you about. Very important topic. 140,111 people filed with more than one lawyer, and they've got two cases on file. I don't know. People think if they get more than one lawyer, they're gonna. I don't know what the reasoning is behind that. Maybe it speeds it up or something, but it doesn't. The fact of the matter is, if you have more than one lawyer, it slows it down, because the first thing that, as you can see, the first thing the court had to deal with were duplicate representations. And if you have duplicate representations, a lot of the lawyers won't work on a case until they clear it up that they're the one that's going to have the case. But there's some cases where we actually have as many as 6 duplicate representations. In other words, one client signed up with 6 different lawyers, and that doesn't accomplish anything. Our firm doesn't do that. And first of all, it's unethical for a lawyer to sign a contract with a client that they know is represented. We don't do that. We didn't do that in any case. It's not ethical. So if I go to sign up a client, one of the things we ask them, do you have another attorney? If we do, then we say, well, I'm sorry, but we can't represent you. You need to stay with your original attorney, or you need to fire the original attorney and hire another lawyer, which could be us. So let me do this with you on dual representation. We have quite a number of those are ours. So let me tell you this. If you have signed up with another law firm in addition to ours, please call my office and tell the receptionist that you have more than one lawyer and you need to speak to me personally. And if you are one of our dual reps, then you can't reach me directly through that number, but you call and tell the receptionist that you have a dual rep and you need to speak to me. She'll give it to me and I will call you back. I guarantee you I'll call you back personally, because I've got to get these dual representations taken care of. And in every case we signed them up, and we didn't sign up anybody else's cases. We never do that. So I want to make sure that you know that you're being represented, but you need to do away with other representations, because things have gotten very nasty on that already, and it's just slowing up the whole process. So that's the first issue, is dual representations. So call me personally, call me and I'll call you back personally and we'll take care of that. Now, I'm going to try to explain to you what's going on right now because you're one of 409,889 people with a case pending. Now, not nearly that many people are going to be paid. So I want to explain to you what you can do to help us make sure that you're one of the ones that gets paid. So I'm going to start by telling you how they decide who gets paid and whether or not the fact that you have a disease that is being paid, that in and of itself doesn't mean you'll be paid. So I want to explain to you very quickly the system. It starts with the ATSDR, which is the Agency for Toxic Substances and Disease Registry. So that's the organization that reads scientific studies, and they make studies of things like kidney disease and bladder cancer and things of that nature. They read the studies, and then they make their rating on it. Now, first of all, you have to pass muster with studies done by ATSDR. Now, we have a break in this case on the burden of proof. We have to prove for you individually, every one of you individually in your case, that there's a relationship between the water at Camp Lejeune, the toxic water, and the harm that you've suffered. If it's kidney disease, we have to make a link between the water at Camp Lejeune and your particular case of bladder cancer. And in addition, we do that. We have to meet the burden. We have to show that there's a relationship that is sufficient to conclude that a causal relationship exists. This is called proving causation. This is why you have a disease and it's covered and you get paid. This isn't like insurance. So we have to show that the causal relationship exists. That is to say, we have the burden of proving that your drinking the water or being exposed to the water was a cause of the kidney, bladder cancer, or whatever you have. So you also can prove, and this is where we got a big break, because normally you have to prove that it's more likely than not that there's a causation. In writing this new bill in the Camp Lejeune Justice Act, it's the burden that we have is to show that there's a cause is at least as likely as not, which is a lighter burden. And this comes out of the epidemiological studies. And here's how their classifications are. When the ATSDR will look at a disease like bladder cancer, and they'll look at the studies, the studies that have been published on bladder cancer. And then they'll either say, okay, these studies are sufficient, which means that they conclude that a causal relationship exists. Or they can say that it's equipoise and above. This is where we got that easier ride with that second part of the law that we changed in the Camp Lejeune Justice Act. Evidence is sufficient to conclude that a causal relationship is at least as likely as not. Okay, that you would not recover under regular law for that, but you do recover under the Camp Lejeune Justice Act. Now, the ATSDR also will conclude that it's below equipoise, in which case they're saying there's not a sufficient relationship between your bladder cancer and the exposure, or they say the evidence that shows that there is no causal relationship. So And each one of we probably have 60 diseases represented in these 410,000 people. So we have to narrow it down in this fashion. We're looking for volatile organic compounds, which are these. These are the 4 exposures. These are the toxins that will get you a recovery if you can show the causation. So here's on ours. I'll show you how this works. On kidney cancer, for example, we show these 3 studies on kidney cancer. The toxin that comes into play that causes kidney cancer is TCE. And on the right, you see it's sufficient. That means that ATSDR is sufficient for proof. Now, non-Hodgkin's lymphoma, leukemia, liver cancer, bladder cancer, major cardiac birth defects, those are all sufficient, and those are the ones that you see. You see the toxin that caused them. The others are Parkinson's, kidney, multiple myeloma, and systemic sclerosis or scleroderma. You'll notice those are not sufficient, but they are equipoise and above according to the ATSDR finding. Now, equipoise and above is sufficient under the Camp Lejeune Justice Act. So these you could not recover under a normal lawsuit, but you can under Camp Lejeune because of the way we wrote the burden of proof. We did a bunch of focus groups with qualified North Carolina jurors, and these are the injuries. These are the tier 1 injuries. We had them rank them in order of what they thought were the more serious injuries. They're liver cancer, kidney cancer, leukemia, bladder cancer, kidney disease. And let me mention, kidney disease, a lot of people think they have kidney disease when what they actually have are kidney stones, and that is not covered. The next one is non-Hodgkin lymphoma, multiple myeloma, cardiac birth defects, of which there are very, very few, Parkinson's disease, and scleroderma. So these are the 10, these are the tier 1 cases. Now, I will show you how we have to evaluate these and to show you, you can have a liver cancer, problem, and you have to show, first of all, we have to show that you were exposed to the toxins, the TCE or the vinyl chloride. Either one of those will cause, but we have to show that while you were at Camp Lejeune, you were exposed to TCE or vinyl chloride. So basically, you have to prove, number 1, that you were at Camp Lejeune. Number 2, that while you were at Camp Lejeune, you were exposed to the same toxin that causes your problem, like TCE for liver cancer. But then you have to prove exposure, and then you have to prove that the amount of time that you spent at Camp Lejeune. And so then we go to past that, we go to the ATSDR. We have to have the science backing up your individual claim for liver cancer. Well, the science, ATSDR has studied 3 different studies here, and they come in and their conclusion was that it's sufficient evidence for causation. Now, for the most part, on these tier 1 injuries, the tier 1 injuries there's sufficient science on kidney cancer, leukemia, and this says all types of leukemia, but right now, the Department of Justice is trying to say that some types of leukemia are not included. So they're going to come in, and it's hard for them to get around these ATSDR studies because those are federal, they're reviews, because that's a federal agency, and the DOJ is a federal agency, and it's kind of hard. The defendant is the United States government, and that's a government agency, so that makes it pretty hard for them to dispute it. So what they have to do is they have to dispute your specific causation. So even though you have bladder cancer and you were exposed to PCE, that doesn't mean you recover automatically. We have to recover. We have to prove your specific causation. That in your case, there was sufficient exposure for you to have the bladder cancer, and this is the kidney disease. And again, that's not kidney stones. Non-Hodgkin lymphoma, these are all, now what they do, these are all, they're not admitted at all they're not admitted as far as specific causation is concerned. But for general causation, these are the ones that are pretty much the Department of Justice goes along with. So that's why they're the tier 1 cases. So it's hard for them to go against this. But what they do is they can come in, they can still, even though they're a tier 1 case and even though it's a government study, they can still come in. You'll notice these studies are from 2013, 2011, 2010. They'll come in and say, yes, but there was another study in 2018 that was much bigger, much more conclusive, much larger study, and it goes against these findings. So they can still come in and attack general causation if they have new science. So, but the main thing they're attacking is you and your exposure at Camp Lejeune to TCE, PCE, or benzene. Now, there's so many different ways to get exposure. It's not just drinking water. This is multiple myeloma, and then cardiac birth defects, of which there are very few because it's birth defects, and then Parkinson's disease. Now, one of the things that we're looking for in the medical records in these, and if you have anything that will help us, it would help us if you can tell us, because they're asking, especially on something like Parkinson's, when was your first diagnosis? When were you first diagnosed? Now, that's hard with Parkinson's because Parkinson's is a whole series of symptoms, and you may start out with just difficulty with balance, difficulty with just that one sentence, or shaking. And then you may have 3 or 4 of these before a doctor finally puts it all together and says, hey, you have Parkinson's disease. So, but we need to know for everything, not just Parkinson's. We need to know for everything, when did you get your first diagnosis and who was it that diagnosed you? And we got to be sure and get that medical record. And then the last one is scleroderma. Another indicator, and this is just the VA. These are the ones that the VA say, but these will qualify you just for health care. These qualify you for health care, and these also are ATSDR rated. Now, one of the reasons why you still, even though you don't have an ATSDR sufficient rating, and you may still have an opportunity to prove your case, because if you, the reason I'm showing you this one, notice that the center, ATSDR, no rating, no rating, no rating, no rating. And then they had one below equipoise, and then below equipoise. But you see, the ATSDR didn't make a rating. So if you don't, they may be saying, well, you don't have an ATSDR rating. Okay, that's not the only rating out there. So if the ATSDR didn't study your problem, for example, look at breast cancer. Breast cancer is definitely, female breast cancer is definitely below equipoise, which means it wouldn't qualify. But male breast cancer, it says there male and female, But there's been more recent studies that show male cancer does qualify and is acknowledged. So, yeah, we have to keep up with the very latest in these to make sure we've got all the information. Uh, this is what Navy JAG. Navy JAG is the one that administers this because the Marine Corps, of course, is administered by the Navy JAG. So these are the 10. These are the same 10, except they throw in other kidney diseases, and then they throw in other myelodysplastic syndromes. They have the same 10. They have the tier ones, plus they throw in a couple of extra things. But this is what they acknowledge. Now, what this is for their purposes for filing your claim with the Navy, which all of you have a Navy claim on file. And these are what they acknowledge. Now, they, however, did not make any awards at all. So now we get to below equipoise, evidence not sufficient. Against equipoise, you got to get other studies from somewhere. Okay, so that's what we have on the. Just go ahead and take that off because I want to talk to you now about what's most important that we really need from you. Medical records. You see from this, you have to prove your diagnosis. So you have to prove your time on the base, that you were there, where you were there. Did you live at Hadnot Point? Where did you live at Terrible? Where did you live there? But remember, it's not just they'll try to get you. Well, we didn't have any problem at that place where you lived. But remember, and this is you might give some thought to this and write it down because we're going to have to deal with it. Water is everywhere. If you were training there and you went out on the training every day, and you took your canteens with you, and they brought the water buffalo out, and they filled up your canteens a second time, and all the water that you drank while you're in training. But then remember that the water, it's in the pool, it's in the showers, it's in all the games you play where you're sweating, and you go work out at the gym, you sweat in, go in, take a shower. Take a shower after your training. That all counts, and especially the steam from a steam shower, because the way it comes in, you're getting direct contact, but you're also inhaling it, and so anything where you have steam as well from hot water, it's in the food you cook, it's in the food you're eating, it's in the water that you wash the baby with. It's everywhere. So think about everywhere that you're exposed to water, because exposure to the toxins is, we prove, by exposure to the water. And so that's absolutely vital to us. So think about your exposure. Exposure is a very, very big deal, and you can't win without it. Now, we have a lot of evidence, and we're doing some work is being done right now, what's called water modeling, and there's a lot of evidence about all the work it's done. We have a Parkinson's patient who had an office job. He never went out and trained. He had an office job. He had a water cooler in his office where he drank the water. But in talking to him in detail, I thought, well, he's kind of scant on the exposure. But in talking to him in detail, I found out that in the last 3 months he was there, that he hadn't qualified in his first month on swimming. And so in the last 3 months he was there before he was going to get out, they reassigned him to the pool. So he went over, qualified for swimming, and just spent the rest of his days in the pool. He's in the pool every day teaching others for 3 months. So personal anecdotes like that is the type of thing that you should be thinking about for yourself. Where was I exposed to water at Camp Lejeune? And then we prove the toxins were in the water towers. They were in 2 of the 8 water towers. Okay, so right now, the proof on exposure is being fought out in a battle over proving water modeling. So that's going on. That's going on right now. So they have what's been done so far. Discovery on these. When you take these studies that I showed you from ATSDR, then we have to have an expert witness that says that yes, TCE has a connection and causes a causative connection to this disease. Now, he takes those ATSDR reports, studies that you read, and then he'll write a report on your case, the individual case. And if we tried your case, he would have to go to trial and testify that in your case, that there was exposure. And that's where exposure comes in. You would give testimony about your exposure, and then he would come in and testify that the toxins are there. This toxin is there. There was so much. Here's how much exposure there was to that toxin, and in my opinion, it's at least as likely as not that the exposure to the water was a cause of the disease. So we have to have expert testimony on every one of you making that causative connection. That's why this thing takes so long. Now, so far, we've completed all the testimony on water contamination. There's been a bunch of testimony about what toxins are in the water, where it's located, and all that sort of thing. There's been a lot of testimony already on deposition on general causation, just generally that this toxin causes these diseases. And then third, there's been testimony on specific causation, that in our bellwether cases, this toxin was a cause of this disease in this bellwether plaintiff. Now, in order to do that, that's all completed. All those depositions are over. Now, before you could give those depositions, we had to qualify those experts with what's known as the Daubert challenge. That is, we have to have a hearing for each one of those experts. The judge listens to their credentials and decides, and their expertise. Then they listen to specifically what studies did you review and what do you find in those studies. They support your opinion that there's causation. And then their final opinion that there is causation has to be supported by sufficient scientific evidence. And when you present all that, then the court says, okay, you're disqualified. You don't have enough credentials or whatever. Or they say you're qualified, you can testify. Or they'll say you're qualified on points 1, 2, 3, and 4, but you can't testify to points 5, 6, and 7. So all that process has to be done, and that's all been done. So now that's in process right now. So we're attacking their experts. They're attacking our experts on hearings. Now, one thing I want to mention, because it's different than what we normally tell clients, here's what you're going to have to produce at some point. So you may as well get it ready now, because we don't want to wait till the last minute. You're going to have to produce a birth certificate, and you're going to have to produce your full Social Security number. Now, normally I would tell you only give your last four to anybody. Don't give your Social Security number to anybody. But let's face it, the U.S. government already has it. They gave it to you, and they're requiring all the digits. So be prepared to give your Social Security number. And then there's other things that you need. For example, if you are not the military person, if you're the spouse, the engineer, the visitor, whatever, then you have to, if you're a spouse and you're claiming off of your sponsor who is in the military and you're claiming through him to have a disease, you have to have a marriage license, a marriage certificate rather. You have to show your marriage certificate, and your marriage certificate has to be your certificate of marriage to that sponsor. And then if you're a child claimant and you're claiming through the sponsor as your father, you have to have the birth certificate. And the birth certificate has to show that the sponsor, the military person, is listed as the father. And then everybody's going to have a government issued photo ID. So you may as well pull these things together now. So in certain cases, it's marriage certificate, birth certificate, government issued photo ID, Social Security number, and then you may as well produce those to us now, and we'll send you a list on this because we don't want to wait and try to track it down at the last minute. Okay. I got to make sure I leave enough time here, but I want to cover everything. Okay, so we're in the process of right now, with respect to every person, every one of you, identifying your qualifying disease, getting your medical records. And we have to have your medical record to do that. Then, because the expert witness, in order to give a specific causation record, he needs your medical records. So, in order to write a report supporting your position. So, let's talk about the most important thing that you can do for us at the moment and do for yourself at the moment. We have to have your medical records. There's no way around it. You can get your medical records through your own portal, through your military records. You got a portal, and you can go if you need help getting records from your military portal on your VA records. Call us. Call your case manager, and we'll walk you through it. We'll even get on there and help you get them. But that's the easiest way to get it. But only you can do that. So you can't just give us the information. We go get them. We do that in a heartbeat, but we can't. So every one of you has to make it. If you were military, every one of you has to make it. You ought to make it your project right now to help us get your medical records, because nothing moves forward without medical records. You get to that point and stop, and nothing else happens. Now, we're going to send to all of you. We've sent this before, but we didn't get them all back, so we got to get them all back. We need HIPAA forms. The HIPAA forms, along with a listing of your doctors and hospitals. The HIPAA form needs to be signed with a wet signature. In other words, we can't send them to you and digitally and have you sign it that way. You have to sign it personally. The HIPAA form the VA form, which allows us to get your medical records, has to be signed with a wet signature. And the so when we send these out to you, there's our form, which works with most medical providers, and we use a standard form, wet signature. Some of the hospitals will not use accept the standard form. They have their own form. So you may sign a HIPAA form. We send it out. They won't let us have the records because they have their own form. So if you have that, then we have to get that form, send it back to you, get you to sign it, and send it back with a wet signature. The VA form, same thing. We'll get it, send it to you, and be sure and tell us, like just like with your hospitals and doctors, be sure and tell us every VA hospital that where you were treated. So if you need help on this, on anything having to do with getting your medical records, that's our biggest project right now, is getting medical records. We've done all this other scientific research. We've been buried in that. Right now, the most important thing we're doing and the most important thing you can do is to get your medical records and help us get your medical records. If you have any question about it, call and ask the receptionist to connect you to your case manager, and your case manager will walk you through that. But that is extremely important. Now, there are a number of things that we're going to have signed, and as we go through this, and we're going to have to get PFS information and plaintiff fact sheet information. Right now, we're having a terrible time in AFFF because the court came up on very short notice and said, okay, everybody has to have all these things done in 98 days. Boom, like that. And so people who had never seen it, we've done the same thing. We've been begging for medical records. But people who don't have their medical records and who haven't sent their medical records, we have to file at the end of 98 days, which is right now in AFFF. We have to file all these documents. We have to file 9 different documents. And we're just having a terrible time with it because we don't get the contact with the people. So we've been doing this for months, trying to get medical record people to sign medical records. And so we need to do it and do it now, because in AFFF, if we're not able to provide medical records to support the claim will be dismissed. It'll be dismissed. And so it's serious business. And if it comes up for mediation, putting your case into the matrix, that won't happen. If you don't have a medical record, you don't even get to talk about settlement. So trust me, that's the most important thing I can raise with you right now. Let me talk to you for a few minutes now. But please, if you get a phone call, if you get a call and need to make a call back, make it, because client contact is the biggest problem that we have. And I can make it as simple as I can. If you don't keep client contact and we don't have medical records and we can't support your claim, your case will be dismissed. Not by me, by the court. Okay, so let me tell you about, I'm going to go quick short time here and tell you what the settlement masters are doing. 2 settlement masters were appointed a year and a half ago to come up with what they call a global settlement. A global settlement is one where you settle everything at one time and you try to settle everything. I wish they wouldn't do that. I suggested that we settle individually. We do a matrix on bladder cancer, for example, and then if we get that done and put figures on it, everybody who's got a bladder cancer case can be settling their bladder cancer cases right then. And then you're doing 3 or 4 or 5 or 6. Then you move through all the cases, establishing your matrix. If they do a global where you have to have everything done at one time, boy, that's a lot, because like I say, they're acknowledged at least to be 40 different diseases that have some science supporting them on this. But there's not going to be nearly as many. There's not going to be 409,000 settlements in this case, I'll tell you. It's going to be a lot less than that. But you've got to be sure that you're doing everything you do, so you can do. So a matrix this is how this is what they're working on right now, and this is how your case will settle. Is they'll take bladder cancer, for example, and they'll put into a box, a matrix. They put in all the symptoms, all the types of injuries that you get from bladder cancer, and they'll put in every element of damage that they can think of. And then they will match that. They'll come to a negotiation on that matrix. So each element of damage that you have, for example, surgery, various types of things. If you're on dialysis in kidney cancer, kidney disease, all those things have value. So then they negotiate the amounts that go into each one of those boxes. So then the idea is that you can go to that matrix and you can check off the boxes that apply to you. And you check off everything that applies to you. And it either gives you points if you use a point system, or some of them just use a straight dollar system. And they'll say, okay, here are the points you have, or here's what your total dollars are if you match for the number of boxes that you match in that matrix. But you have to do a matrix for each individual, to cover all of the compensable diseases. So these people are saying that their plan calls for them to have a matrix for assigning values to claims and claimants done in the fall of 2025, which would be approximately started October 1st. Well, they're way behind on that. That was extremely ambitious. So the first thing they have to do is divide the universe of injury and conditions that'll be part of a resolution. So they go through this and they find out that they got 60 different types of diseases that they're claiming. They're not going to pay 60 diseases. They're going to look back at the ATSDR. They're going to look back at the science. They're going to take all the science that came up in the hearings with the court, and they're going to decide these are the cases we're going to pay. We will not pay any other cases. And they will review each one and say there's not sufficient science to support it. So supposedly the first thing that we're going to do is to decide which conditions, which diseases will be paid. And that'll be done by, of course, the Department of Justice, because they're the ones paying it. So now the Department of Justice has pretty much agreed, as far as general causation is concerned, on the tier 1 cases, those top 10 cases. So if you got one of those and you can make specific causation, you're in good shape. But once they do that, then a lot of these cases, thousands of these cases are going to drop off, because they're going to tell us these are the ones we're going to pay. And then if we have some that we feel we can make, we can still leave them and try to get them set for trial, file them and try to get them set for trial. So they've done some work towards deciding what this matrix looks like. This matrix is very, very difficult. At the moment, they also they just completed gathering information from 2,500 claims. Some of you may have had we sent out, we had 16 of them that we sent out of our clients that filled out a big long questionnaire. They got that from 2,500 people, and they're using that to gather information to go into the matrix. They're very, very far behind on the idea, especially if they're going to try to do a matrix. So let me just leave it at this. The parties agreed to mediate track 1 bellwethers. They mediated acute leukemia, chronic leukemia, bladder cancer, kidney cancer, non-Hodgkin's lymphoma, and Parkinson's disease. They finished the mediations. They settled 3 of them, and they say they're working towards finalizing a matrix and global settlement for resolving a significant portion of the claims. I mean, it's going to be, I almost guarantee you, it will be at least this time next year. It'll be Q4. I think that we will, despite their hyper enthusiasm, which has them settling them now, it's just not going to happen. There's just too much to do. And so I think I won't be held to account for this. I'll just give you my opinion. My opinion is by the fourth quarter of next year, possibly earlier, if they try to do a full global matrix and try to settle everything at one time, it'll be Q4 of next year. Now, if they take them one disease at a time and do matrices, they could be settling those earlier than that. So let me leave a few minutes here for questions. And let me bring in Allison Whitten. Allison works every day on these cases, on your cases, right alongside me and a whole bunch of others of us. We have a ton of people working on these cases. So let's go over the relevant questions from the chat room, Allison.
Okay. Hello, everyone. We've got 5 questions so far. If you have a question that you haven't asked so far, please put it in the chat and we'll get to it. First question is that you indicated that you are handling death cases. If so, her mother died of non-Hodgkin's lymphoma in 2016. When will I hear about her case?
Okay, let me tell you about death cases. Right now, we're working with a firm in North Carolina, right there where the court is. We've made a deal with the judge, with the clerk of the court, actually. We've made a deal that we can file auxiliary get an auxiliary appointment for just handling the wrongful death and survival claim. So several things obtained here. Number one, if you have already had if they had a will, that's first. If you had a will and the will was admitted to probate, we need to know that. And then, of course, we need to know who was appointed. We need to have the administrator contact us we need letters of representation and so forth. and if you have a lawyer handling the estate, we certainly, it would be simplest thing, just be have give us the lawyer's name or have the lawyer contact us, because the simplest thing, instead of running around all over the country with a whole mishmash of probates, what we would do is um, is open an auxiliary administration right there in North Carolina. We'll have a very smooth system set for having it done. Our lawyer, we have lawyers on that, but the lead lawyer on that is Arlene Cologne, and she would be handling the opening of the administration, an appointment for an administration for the sole purpose of doing the things necessary to settle the case and to sign on behalf of the uh, uh, to uh, to sign on behalf of the estate. And there's a lot of papers to sign at the end by the administrator in a death case. And so uh, the other thing is, uh, if you have a will. If you've had a will and the estate has been closed, we'll do the same thing. We still need to know who the administrator was or the lawyer was on the estate, because they might have a lot of information that we need. But we would tell them, we'd do the same thing. We'd just open the auxiliary administration, but we need to file the original administration papers to show the court that it's closed and so forth. So same thing there. So if there has been an administration, uh, get me the name of the administrator, send us the name of the administrator, and or if it's still got a lawyer on it, the lawyer, and then we'll take care of that. If you do not have an administration, if an administration has not been opened, then we'll talk to the family. We'll talk to whoever's running things for the family, the spouse or whoever, and we will advise them about setting up the administration. And we would go through the setting up of the administration, the same thing. All of our administrations are going to be set up right there where the court is. And because they're ready to handle them, we don't get involved in any other aspect of the administration. And so we do have, we have 800, let's see, we have close to 900 death cases. And the other thing we need from you would be death certificate. We need a death certificate, and in the rare case where there was an autopsy, we also need the autopsy. That can be extremely valuable. So there's two types of deaths here. One is someone who has a wrongful death claim, that is to say that the toxic water at Camp Lejeune killed them, and they have a claim for that. The other one is where they're dead, but but they did not die as a result of the disease. They died. They got hit by a car, whatever. So they just have a death. They may have an administration that hasn't done anything or thought about a case, but we need to know about that, and we get that distinction. We may not. The only thing we might need there is just an administrator who can sign on behalf of the decedent, but we can get that done, or we'll see if that's already been done. So all those things on death, we've got it all taken care of, and we got a system in place for it, and we're handling them right now. So what else do you have?
One person saying that their father died over 30 years ago, and they've been told by the hospital and the doctors that their medical records have been destroyed. What do we do with a case like that?
We have a lot of that, and that's a problem. And you can imagine that's a problem that we're dealing with, because these things happen between 54 and 87. And gosh, when when you think about that, this, I mean, this is how old this case is. This this was going on when I was in high school. Seriously. Uh, and I'm over 21. It's just been that long. So of course we're going to have a huge problem with just exactly what you're talking about. Our first thing is to try to see if we can replace medical records, and the court is aware of this, and the court is sympathetic to it, but the court still has to follow the law. So what we're working on is getting the court to accept, in places where there's an absence of medical records, accept affidavits uh, concerning if there are doctors still available, uh, if there's uh, anyone from the medical field that's still available that could get an affidavit about the injury. If not, we just have to ask for the affidavit from the spouses of people who were there and can give their testimony. We haven't got that. We don't have that worked out yet as to what the parameters of that will be, because it's going to be a case by case situation. But if they'll let us go back to, and we can go back to the hospital um, and get an affidavit. First, we'd have to get an affidavit from the hospital that the records are lost. But then if we get an affidavit from anybody there at the hospital who was a doctor who was participated, so that's a case by case problem, and it's a big one. But we're working with the court on trying to solve it.
Okay. Couple questions about people who have sent documents to our office and that they haven't received confirmation that we've received them. So what should they do?
Well, we don't send out confirmation because with all the papers we get, it's all we can do. And I understand that, but it's all we can do to handle the incoming papers, because there's, with this many clients and us getting in, we're literally, before this is over, we're dealing with hundreds of thousands of pages of medical records, not to mention all the other things, not to mention all the other parts of this that we're having to deal with. So um, if you have any question, if you don't hear from us, you'll hear from us if we don't get it. If you send something in, if you've sent your paperwork in and you get another letter from us or an email from us saying, please send this in, that's when you call us and ask, look, I sent this in, and see if you can get it verified. And they can verify we either have it or we don't. But unfortunately, as many people, we have 55 or 60 people working on this stuff that are handling it, just to handle the paperwork and shuffle the paper and do all the work that has to be done on these. But if we had to start calling back to confirm for everybody, yes, we got your paperwork, we simply don't have time to do it. Sorry. But if you get a second notice from us that we need it, then definitely call us and talk to your case manager. If you have any question whatsoever about it, call your case manager and ask them. What else you have?
All right. We have a client who's asking about lung cancer claims. Where do those stand?
Right along with the rest of them, right there. They're one. They're right now on lung cancer. There's additional work being done on the cases that will, to bring them all up to date. So everything is subject to improvement. Let's put it that way. But so the final in the tier 1 cases, are the only ones I'd say that are absolutely finalized right now to the point where they are either they just said, okay, we've got all the information we need. And even on those, they're still being uh, they're still being questioned on specific causation. What else you got?
Okay. Client saying that they have recently filed for a disability rating with the VA for kidney disease. And the original claim was denied, and now they have another law firm handling their VA disability claim. Does that conflict or affect this Camp Lejeune Justice Act claim?
What they should do, we work with lawyers every day that do this. What they should do if you have a disability, in fact, we refer our disability claims out to a particular firm that specializes in it. So what we should do is have your lawyer handling a disability claim contact us because, for example, they may already have medical records, or we may be after the same records, and maybe we already have what they're looking for. Maybe they have what we're looking for. So just give us the name of your disability lawyer, and we'll call them, or give them our name and let them call us.
Okay. And some people, I think some people may have come in late and they were asking just for a quick summary on where things stand with a possible settlement.
About a year away
At the earliest, by the
at
way,
the
too. That, yeah,
earliest. Yeah,
yes.
to begin settlement negotiations. According to the according to the settlement managers, they said it was going to be right now. They said that they'd be settling cases by the end of the year. They are so far away from settling cases. They just they're they're just so they're just not connected. I mean, they don't understand the complexity. Um, if they insist on a global settlement, I think the earliest is going to be Q4, the last 3 months of next year. If they do it by individual diseases, we can start them pretty soon in 6 months.
Okay. And if we didn't get to your oh, just one more, we'll do one more question. And then if we didn't get to your question and still needs to be addressed, please call your case manager and then we'll discuss your direct questions exactly, because I think some of you have more too. But someone, just one more thing, asking what happened to the jury trial process, because now we're back with bench trials. Is there any
That's
progress on that?
well, when the bill was written, there's a very clear, specific provision in there for a jury trial. Because under the Tort Claims Act, which is what was there before, when you people could not sue the federal government, uh, we created the Camp Lejeune Justice Act to give you the right to file suit. We created this cause of action. And in the Tort Claims Act, you do not get a jury trial against the government. In this case, we had a very specific provision saying we get a jury trial. The Department of Justice came in and opposed it, saying we don't get it, that we shouldn't get a jury trial. The courts, to our surprise, the courts upheld it and said, no, you don't get a jury trial. Because if there's one thing that it's bad enough for the courts, at the time, the courts were looking at 550,000 cases to handle. And it would be so much worse for them if they had 550,000 jury trials to handle. Now, of course, there's not going to be anywhere near that many. That's what the court said in the first session. He said it would take longer to try these cases to a jury than it took than the length of the Roman Empire, that we would outlive. In the very first meeting, the judge said, asked the U.S. attorney, how long did the Roman Empire last? And he asked the lawyers, and they didn't know. So he said, well, I think he said 1,400 years. Lasted 1,400 years. And if we have jury trials in this case, it would take us longer than the Roman Empire lasted to try jury trials. Those are the same judges that made the decision that we're not going to get jury trials. We took it up to the court. We took it up to the Court of Appeals, and they agreed with them. And it is true. I mean, first of all, if it were jury trials, it would take us forever to get to them. That's one thing. And the idea of bringing in 35 or 40 jurors for every trial, whereas in a non-jury trial, you could try these in one day. You try this case in one day, which is what they plan to do. So, two at the most. A jury trial would last 3 or 4 days or a week or longer. So they took it away. They simply took it away. I mean, we had it in the statute by Congress, but they simply took it away.
Okay. Well, I think we'll wrap it up then. And then just one more point of clarification. I think Howard had said to send birth certificates. We only need that if you were a dependent child of a sponsor. We don't need that in general. Otherwise, we just need that to prove the relationship if you were a dependent child. Otherwise, we just need a government issued photo ID.
Yeah, but we have to prove date of birth and full Social Security number in every case. But you
Right.
don't have to have your your government ID will probably have your birth date on it. So that would be sufficient. But you do have to prove that's the two identifying things that they're using. That's why they want the full Social Security number, and date of birth. Okay, please, please get your medical records from your portal and send them to us. If please, when we send you documents, which we're going to do soon, please sign them and send them back. And wet signatures. We have to have the wet signatures. Otherwise, I'll tell you what will happen. This time next year, we'll be calling you saying, you know what? I'm sorry. They got the matrix finished, but we never did get your medical records, so we can't tell where you fit in the matrix. I don't want to be asking you for them this time next year, so please make that your Christmas present to me. Go get your medical records, please. And when we call you, answer your phone and absolutely if you have a phone number change, if you have an address change, keep in touch with your case manager. Always let us know. Because we sent out a bunch of USPS overnight 2-day packages with a return envelope that cost us $22 each, and a bunch of them were returned wrong address. A bunch. It just cost me that much money because people had not updated their address with us. So keep us up to date. Keep contact with us. I'm a nice guy. Keep in touch with me. So thanks a lot. I'll be back in about a month. We'll do this again in about a month.